Ever felt like you're studying for something really important, like a big exam, and then you take a practice test and hit those specific questions that just make your brain, seize up?
Oh, absolutely.
Wait, what was that again?
Yeah,
Moment, even after you've pored over the material. It's a common stumbling block, right? Trying to turn that memorization into actual understanding.
it totally is. Information overload is, well, it's real. And it's especially true in a field as complex, as nuanced as real estate. A practice test isn't just about showing what you know. It's really a diagnostic tool. It
Ugh.
tells you exactly where those concepts need a bit more digging, where the connections aren't quite clicking yet.
And that's exactly what we're planning to do today for you. You've gone through that practice test, you've seen where the tricky spots are, and now, well, we're going to turn those moments into rock-solid understanding. Our mission in this deep dive is to unpack the core principles of California real estate, focusing really specifically on those areas you flagged on your test. We want to give you a clear, concise, but still really comprehensive review.
Yeah, helping transform those maybe initial aha moments into something durable, something you can actually use.
Exactly. Confident knowledge.
And our foundation for this chat comes straight from your California Real Estate Principles Study Guide and, crucially, the insights from your practice test. Think of us as your study buddies, maybe, guiding you through the stuff you've already seen, but with more clarity, context, and, the practical side to help it stick.
All right, let's dive in then. We should probably start with one of the absolute fundamentals, agency relationships.
Yeah.
This really is like the guiding star in the real estate world, isn't it? It affects pretty much every interaction.
It really does. When we talk about agency, we're defining a very specific legal setup. It's where one party, the agent that's typically the real estate broker, is authorized to act for another party, who we call the principal or the client. And the core idea, the absolute bedrock, is that the agent must act in the principal's best interests. Now, what's critical in California real estate, and this trips people up all the time on tests,
Yeah.
these agency agreements must be in writing to be enforceable. It's not just like a suggestion, it's a hard requirement.
So no handshake deals for listing a house then?
Nope, not if you want it to hold up legally. It's the safeguard, Prevents disputes, protects everyone involved in what's often a massive financial transaction. That piece of paper is key.
So more than just trust, it's about that legal clarity. And it's built on, what, 3 main parts?
Exactly. 3 core building blocks. You need
Yes.
the 2 parties, obviously, the agent and the principal.
Right.
You need an agreement, that mutual consent we just talked about, which, again, better be written in California.
Yeah.
And then the big one, that fiduciary obligation.
Fiduciary obligation. Okay, what does that really boil down to for an agent?
It signifies the highest level of trust and confidence. I mean, legally and ethically, the agent is bound to put the principal's interests above everyone else's, including their own. It's the gold standard of professional duty.
Wow.
And what's interesting, and ties into how brokerages work, is who actually creates this relationship. It's created at the broker level.
Ah, okay. Not necessarily a salesperson you're talking to day to day.
Right. While you might work closely with a salesperson or maybe a broker associate, they're technically called associate licensees. They work under the authority of their sponsoring broker.
So they're agents of the broker.
Yes, agents of the broker, and then they act as subagents for the broker's clients. It's a chain of command, really.
Okay, that actually explains that practice test question about salesperson Shahid signing a listing agreement with seller Corinne.
Mm-hmm.
Even though Shahid signed it, the broker is the actual party to that agency contract.
Yeah.
Shahid is just acting for the broker. The broker carries the ultimate responsibility, the liability.
Precisely. And that structure leads right into another fundamental distinction, one that pops up constantly on tests and in practice, the difference between a client and a customer.
Okay, this is crucial. Client versus customer.
An agent works for a client. That's your principal. You owe them that whole suite of fiduciary duties, loyalty, obedience, the works. But you work with a customer.
A customer is like a third party.
Exactly, a non-client third party. You're involved in the transaction with them, maybe showing them a property listed by your client or bringing an offer from them, but you don't represent their interests in that same fiduciary way.
That makes sense. And your test had that example, right? Broker Nathan working for Emily, his client, and with Emilio, the customer.
Perfect example. Nathan's loyalty is solely to Emily. He advocates for her. With Emilio, he provides information, deals fairly and honestly, but he's not his agent.
So even though you don't owe customers those high-level fiduciary duties like loyalty, You still have obligations,
Right.
right? You can't mislead them.
Absolutely not. You still owe customers. And really, all third parties' honesty, fair dealing, reasonable skill and care, and proper accounting if you handle their funds. Those are baseline ethical and legal duties for everyone involved. No fiduciary relationship needed for those.
Okay, so types of agency, how are they classified? Seems like there'd be different levels.
There are, based mainly on the scope of authority the agent gets. First up is special agency.
Special agency.
Think narrow, specific objective, usually short term. And importantly, no binding authority for the agent to make decisions for the principal. The classic example is the broker-client relationship in a typical sale.
So the broker finds the buyer, negotiates, but can't, like, sign the final contract for the client.
Exactly. The broker guides the process, but the client holds the ultimate decision-making power to accept or reject an offer or sign the purchase agreement. The agent's authority is specialized to that one transaction.
Got it. So if special agency is narrow, what's broader?
That would be general agency. This one grants broader authority, often for ongoing tasks, and it can include the power to bind the principal in certain situations.
Okay, like?
Like the relationship between a broker and their associate licensee. Remember Chelsea from your practice test?
Yeah, the associate licensee.
Chelsea is a general agent for her broker. She can perform many tasks on the broker's behalf and can, for instance, sign a listing agreement that binds the brokerage to represent seller Sue.
Ah, okay. But for seller Sue herself, Chelsea is only a special agent.
Precisely. Chelsea acts as a special agent for Sue, meaning she cannot sign the purchase agreement for Sue. Sue has to do that. So you see that hierarchy. General authority from the broker, special authority regarding the client.
That clears that up. And then there's one more, right? Universal agency.
Yes, universal agency. This is the broadest possible form. It gives the agent the power to act and make decisions in all business matters for the principal. Think power of attorney.
Like stepping into someone's shoes completely, legally speaking.
Pretty much. It's quite rare in typical real estate deals, selling a house. You'd usually see it more in situations involving long-term care or managing all of someone's affairs.
Okay, so we know what agency is, the different types. How do these relationships actually get started? What creates them?
The most obvious way is express agency. That's a clear, explicit agreement. Can be verbal, can be written.
But wait, you said in California real estate.
Ah, good catch. Yes. While express agency can be oral in general contract law, for California real estate activities like listing agreements, buyer rep agreements, anything involving compensation tied to a sale or lease, it must be in writing to be enforceable. That written requirement is key for things like getting paid a commission or listing on the MLS.
Right, that written rule again. Okay, so express is clear. What if it's not so clear?
Then you might have implied agency. This is created by the actions, the conduct, the words of the parties, even if they never explicitly said, "You're my agent."
How does that work?
Well, your practice test touched on this. If you start acting like someone's agent, giving advice, negotiating for them, showing properties repeatedly, your behavior can imply an agency relationship exists, and the law might hold you to those agency duties even without a signed paper. It's about the impression created by your actions.
Tricky. Seems like you'd want to avoid that ambiguity.
Definitely. Express written agreements are always best, but implied agency is a real thing.
What about agency created after the fact? I remember something about ratification.
Yes, agency by ratification. This is fascinating. Your test had that example of Sally paying Hank a commission even though his listing had expired.
Right, he wasn't technically authorized anyway.
Exactly. He acted without current authority, maybe showed the property one last time, found a buyer. Sally could have said, "Sorry, listing's expired," but instead she accepted the benefit of his actions, the buyer, and then paid him the commission. By doing that, she retroactively approved or ratified his unauthorized actions, making it as if he'd been authorized all along.
So she validated it after the fact.
Precisely. Then there's ostensible agency, also known as agency by estoppel.
Estoppel. That sounds illegal.
It is. It happens when a principal's actions, or sometimes inaction, lead a third party to reasonably believe that someone is their agent, even if they aren't formally. Because the principal created that impression, they are then legally barred or stopped from denying the agency relationship later if the third party relied on it.
Like if a broker lets their assistant negotiate deals and a buyer thinks the assistant has authority.
Exactly. If the broker's behavior led the buyer to believe that, the broker might be stuck with whatever the assistant agreed to. It's about preventing unfairness caused by misleading appearances.
And quickly, what was gratuitous agency?
Oh, right. Gratuitous agency is simply agency where no compensation is expected or paid. Maybe you're helping a friend sell their house for free. Even though you're not getting paid, all the standard fiduciary duties still apply. You can't cut corners just because it's pro bono.
Okay, good to know. So once we have an agency relationship, how does it end? It's not forever, right?
Definitely not forever. There are basically two main ways agency terminates: operation of law and acts of the parties.
Operation of law sounds automatic.
It is. It means the relationship ends automatically due to certain events, regardless of what the parties want. This includes things like the task is completed, the house sells and closes.
Makes sense.
The agreement term expires, if it had an end date. The property is destroyed, like by a fire or condemned, or, significantly, if either the principal or the broker dies, becomes incapacitated, or declares bankruptcy.
The broker's status affects all their agents.
Yes, if the broker dies or loses their license, all agency agreements under that broker are automatically terminated. The associate licensees can't just carry on without a sponsoring broker.
Wow. Okay, and the other way was acts of the parties.
Right. This is when the parties themselves take action to end it. They can mutually agree to terminate early. The principal can revoke the agent's authority. The
Yeah.
agent can renounce the relationship.
Your practice test mentioned breach of agreement here too.
Yes, that fits. If one party fails to live up to their obligations without a good reason, say, a seller refuses all reasonable, showing requests that breach can be grounds for the other party to terminate.
But can you just walk away? If a client revokes or an agent renounces, are there consequences?
There can be. While parties generally can unilaterally end the relationship, they might still be liable for damages if the termination breaches the terms of the written agreement. For example, a seller might revoke a listing before it expires, but the contract might still entitle the broker to compensation under certain conditions.
So termination doesn't necessarily mean no liability.
Correct. And crucially, some duties don't end with termination. This is a big one, often tested.
Which ones?
The duties of confidentiality and accounting, they survive termination. They last forever.
Forever.
Forever. You can never disclose confidential information learned about your client during the agency period, even years later. And you must always be able to account for any funds or property you handled for them. Those two stick with you.
That's a huge responsibility. Okay, this next part feels really important, maybe a bit messy. Disclosure and loyalty.
Yes, these are at the heart of agency ethics and practice. You've got two main disclosure obligations as an agent. First, you have to disclose your agency relationship itself, who you represent.
Okay.
Second, you have to disclose all known material facts about the property or the transaction.
Let's start with disclosing the agency relationship. When does
Yeah.
that happen?
The rule is as soon as practicable. In reality, this usually means at the first substantive contact.
First substantive contact. What defines that?
It's basically when the conversation shifts from casual chat, nice weather we're having, to specifics about a property or the buyer's or seller's needs, motivations, or financial situation. That's the trigger. You need to provide the official agency disclosure form then, explaining the different types of agency available.
And this ties into informed consent, which your test flagged as critical.
Absolutely critical. Informed consent means the clients and customers don't just get the form, they actually understand who represents whom and what that means before you move forward with that relationship. They have to agree to it knowingly.
Especially important in dual agency, I imagine.
Especially then. Dual agency has inherent conflicts, so getting clear, explicit, informed consent is non-negotiable. Without it, the whole relationship could be invalid, leading to lost commissions or even lawsuits.
Okay, let's revisit those fiduciary duties owed only to clients.
Yeah.
You mentioned old DCAR.
Yes, the acronym old DCAR is a great way to remember them.
Oh.
Obedience. You must follow your client's lawful and ethical instructions. Remember broker Jamila from the test? She had to present that offer even if she thought it was low, unless the client gave her written instructions not to. You obey the client, not your own judgment about the offer's merits.
L.
Loyalty. This is paramount. Act solely in your client's best interest, above your own, above everyone else's. That agent trying to delay offers to maybe get a higher commission later, big violation of loyalty. Client first, always. Disclosure. Reveal all material facts you know that could affect the client's decision. This came up with Agent Zlata and listing agent Urbano.
Right. Zlata telling Urbano about her buyer's strong financing was okay.
Yes, that helps the buyer's offer. That's appropriate disclosure. But Urbano disclosing his seller's financial desperation, like losing a job, to the buyer, Absolutely not. That hurts the seller's negotiating power and breaches confidentiality.
So confidentiality can limit disclosure.
Yes, when it comes to the client's private circumstances or negotiating position, you disclose material facts about the property but protect the client's confidential information.
Okay, see.
Confidentiality. Keep the client's secrets private. And remember, this one lasts forever.
Yeah.
Accounting. Properly handle all funds and property. Keep meticulous records. This duty also lasts forever. Reasonable skill and care. Use your expertise diligently on the client's behalf. Do your homework. Advise them competently. They're relying on your professional knowledge.
Got it. Oldie car for clients. And for customers, it's honesty, fair dealing, reasonable care, disclosure of property facts, and accounting. But no obedience or loyalty. That distinction is key.
Super key. Now let's tackle the big ones. Dual agency and sub-agency. These can cause real headaches if not handled properly.
Okay, dual agency first. What is it exactly?
Dual agency happens when one brokerage represents both the buyer and the seller in the same transaction.
One brokerage. Okay, does it have to be the same salesperson?
Not necessarily. It can be one agent representing both parties, or it can be two different agents within the same brokerage, one representing the buyer, one representing the seller. Because they work for the same sponsoring broker, it's still dual agency at the brokerage level.
And this came up with Broker Darnell's situation on the test. His client was the seller, Hannah, and a buyer came from his own brokerage.
Exactly. That immediately triggers the need for disclosure and that critical informed consent for dual agency from both Hannah and the buyer.
Why is consent so vital there?
Because, as your test pointed out, in dual agency, the clients give up certain rights. You cannot provide full disclosure to both parties, some info is confidential to one side, and you cannot provide undivided loyalty. Your duty is split.
You can't fully advocate for both sides on price and terms, can you?
Impossible. Their interests conflict. So the level of service is inherently compromised compared to single agency. That's why everyone must understand and agree to it beforehand.
Okay, that makes the risk clear. Now, what about sub-agency? You mentioned it's rare now.
Yes, increasingly rare, especially in California. Sub-agency is when a cooperating broker from a different brokerage brings a buyer but chooses to represent the seller, effectively becoming an agent of the listing broker, an agent of an agent.
So the buyer has no representation from that cooperating broker.
Correct. In that scenario, the cooperating broker owes fiduciary duties to the seller, not the buyer they brought. The buyer is just a customer to them.
Why is it so rare now?
The main reason, and this ties back to liability, is vicarious liability.
Vicarious liability, the broker being responsible.
Exactly. It's the legal principle that a principal, the listing broker, can be held responsible for the wrongful actions of their agents and their sub-agents.
Ah, so listing brokers didn't want to be liable for mistakes made by brokers from other companies who they didn't supervise.
Precisely. That's why most listing brokers, especially through the MLS, now explicitly reject offers of sub-agency. They'll cooperate with other brokers, sure, but typically only if that other broker is acting as a buyer's agent, representing the buyer directly. They don't want the liability risk of having unsupervised sub-agents out there acting on their behalf.
So the shift has been strongly towards buyer agency.
Overwhelmingly so. It provides clarity and avoids that vicarious liability trap for listing brokers.
And that explains the test question about salesperson Esther's limitations. Her broker gets to decide if she can even do dual agency, right? Brokers set those policies.
Correct. The broker controls the types of agency relationships their associate licensees can enter into.
All right, let's shift gears to real property ownership, understanding your rights. Where do we start here?
Let's start with the different interests one can have in real property. Broadly, you have possessory interests and non-possessory interests.
Possessory means you get to possess it.
Right. The right to occupy and use the property. This includes actual ownership, like a fee simple estate, the highest form of ownership. Or it can be a leasehold interest, where you possess it for the term of a lease but don't own it.
And non-possessory.
These are rights or claims against a property that don't include the right to occupy it. Think easements, the right to cross someone's land, liens, financial claims, or future interests. Your test had that example of a creedy having a non-possessory interest because she's set to inherit the property later. That future right is an interest, but she can't possess it now.
Okay. Now, the ways people actually hold ownership.
Right, the forms of ownership. The simplest is ownership in severalty.
Severalty sounds like several people.
Confusing, I know. But it actually means severed from any others. It's sole ownership by one person or one legal entity, like a corporation. Your test example was Roy owning his condo that he rents out. He's the only owner. That's ownership and severalty.
Okay, sole ownership. What about shared ownership?
That's co-ownership or concurrent ownership, two or more parties sharing title. Two key concepts here are undivided interest and right of survivorship.
Undivided interest.
Means each co-owner has the right to possess and use the entire property, not just, say, the north half. Even if ownership shares are unequal, the right of possession is shared for the whole thing.
And right of survivorship.
This is a special feature. If one co-owner dies, their interest automatically passes directly to the surviving co-owner by passing probate and the deceased owner's heirs. It's a key feature distinguishing some types of co-ownership.
Okay, so what are the main types of co-ownership?
The most common for unmarried people is tenancy in common.
Tenancy in common. Features.
Undivided interest, shared possession. Crucially, no right of survivorship. If a tenant in common dies, their share goes to their heirs or whoever is named in their will. Shares can be unequal, for example, 60-40. And the only shared requirement, the only unity needed, is unity of possession. Your test specifically asked about this. It's the minimum requirement.
Okay, so flexible inheritable shares. What's the alternative?
Joint tenancy. This also involves two or more people, can be married or unmarried. They also have undivided interest. But the defining feature is usually the right of survivorship.
Ah, so if one joint tenant dies, the others automatically inherit their share.
Exactly. It avoids probate for that share. For joint tenancy, the shares must be equal, and it requires the four unities to be created and maintained.
4 unities. What's here?
Unity of possession, equal right to possess. Unity of interest, equal ownership shares. Unity of time, acquired interest at the same time. And unity of title, acquired interest through the same document, like the same deed.
So much stricter requirements than tenancy in common.
Much stricter. If any unity is broken, say, one joint tenant sells their share, the joint tenancy is severed for that share, and it usually becomes a tenancy in common between the remaining owners and the new owner.
Now, what about married couples or partners in California? There's a special status, right?
Yes, absolutely crucial. Community property. California is a community property state.
What does that mean in practice?
It means property acquired by a married couple or registered domestic partners during the marriage or partnership is legally presumed to be owned equally by both, 50-50. This applies regardless of whose name is on the title or who aimed the money used to buy it.
So it's automatic equal ownership for assets gained during the marriage.
Generally, yes. And importantly, neither spouse or partner can usually sell, transfer, or put a major lien on community property without the other's signature. Your test mentioned this specifically for registered domestic partners like Greg and Luke. The same rules apply.
Okay, community property is key in California. What about transferring property after someone passes away?
This involves conveyance after death. The main distinction is whether the person died intestate, without a valid will, or testate, with a valid will.
Intestate.
No will. The state's laws of intestate succession dictate who inherits the property. It can be complicated and might not match what the person would have wanted.
Antestate.
Means they had a valid will. The will itself, as your test defined it, is that legal instrument used to voluntarily convey title to property after the owner's death according to their wishes.
Who manages that process?
If there's a will, it usually names an executor to handle the estate, pay debts, distribute assets according to the will. If there's no will or no executor named, the court appoints an administrator to do the same job, following state law.
Okay. Now let's talk about the proof of ownership itself. The deed. Is a deed the same as title?
Good question. No, they're distinct. The deed is the physical written document that transfers ownership. Title is the abstract concept of actual ownership, the bundle of rights you hold in the property. You receive a deed to prove you hold title.
Got it. What makes a deed valid in California?
It must be in writing, identify the grantor, seller, and grantee, buyer, have words of conveyance, I grant, an adequate description of the property, and crucially, it must be signed by the grantor. In California, the grantor's signature also needs to be acknowledged, usually by a notary public.
Does it have to be recorded to be valid? Your test mentioned this.
No, recording is not required for a deed to be valid between the grantor and grantee. However, recording it at the county recorder's office provides constructive notice to the public.
Constructive notice.
It means the world is legally considered to know about the transfer. This protects the grantee against later claims. An unrecorded deed is risky because a later buyer who records their deed first, without knowing about the earlier unrecorded one, might actually get superior rights. So recording is highly advisable for protection.
Okay. What's the habendum clause that was on the test? To have and to hold.
Exactly. The habendum clause usually follows the granting clause and clarifies the extent of the ownership interest being transferred. Is it fee simple? Is it a life estate? It defines or limits the type of ownership the grantee receives.
And when does ownership actually transfer? Signing? Recording?
Neither. Ownership legally transfers the moment the deed is delivered to and accepted by the grantee. Delivery shows the grantor's intent to pass title, and acceptance shows the grantee's intent to receive it. That moment of delivery and acceptance is the key point of transfer.
Interesting. Okay, types of deeds. They offer different levels of protection.
They do. The strongest is the warranty deed, where the grantor makes extensive promises, warranties about the title, even covering defects from before their ownership. These aren't as common in California.
What is common here?
The grant deed. With a grant deed, the grantor implies two main things. They haven't already sold the property to someone else, and the property isn't burdened by undisclosed encumbrances that they caused. It guarantees title against the grantor's own actions.
And the one with the least protection. Your test highlighted this.
That's the quitclaim deed. This deed offers zero warranties. It simply conveys whatever interest, if any, the grantor happens to have in the property. They might have full ownership, partial ownership, or none at all. It's often used to clear up potential clouds on title, like having a potential heir sign off their possible interest. It provides the least protection to the grantee. And remember, bargain and sale deeds are generally not used in California.
Got it. Quitclaim, least protection. Okay, moving on to things that burden property. Encumbrances and lands. What's an encumbrance?
An encumbrance is basically any claim, right, or interest held by someone other than the owner that burdens the property's title or limits its use. It's a non-possessory interest. Think of it as something that diminishes the value or restricts enjoyment.
Like what?
Common examples are liens, financial claims, easements, rights of use, deed restrictions, limits on use imposed by a former owner, or even a cloud on title, a potential unresolved claim. Your test defined it as that non-possessory interest burdening the title.
What things are not encumbrances, even if they affect the property? Your test mentioned a couple.
Right. A license is not an encumbrance. It's just temporary revocable permission to use property, like letting your neighbor park in your driveway for a week. You can revoke it anytime. Your test stressed that revocable nature. Also, encroachments.
Encroachments?
Yeah.
Like a fence built over the line.
Exactly. It's a physical intrusion onto another's property. While it's a problem, it's technically a form of trespass, not an encumbrance on the title itself.
Okay, let's focus on easements. They are encumbrances, right?
Yes, definitely. An easement is a right to use another person's land for a specific, limited purpose without owning or possessing it.
Can you give examples?
Sure. A common one is an easement for ingress and egress, the right to use a driveway across a neighbor's property to reach your own. Utility easements allow companies to run power lines or pipelines. Conservation easements restrict development.
Are there different kinds, affirmative versus negative?
Yes. Affirmative easements allow someone to do something on another's land, like cross it. Negative easements prevent the landowner from doing something on their own land, like building something that blocks a neighbor's view.
How are easements created?
Several ways. By express grant in a deed, by written agreement, or by law through implication, like if it's clearly necessary for use, or by necessity.
And what's the difference between easement appurtenant and easement in gross?
An easement appurtenant benefits an adjacent or nearby property, the dominant tenement, and burdens another property, the servient tenement. It runs with the land, meaning it transfers automatically when the dominant property is sold. Think of that shared driveway example.
Okay, tied to the land. Engens, gross.
An easement in gross benefits a specific person or entity, not a particular piece of land. The utility easement for power lines is a classic example. It benefits the power company, regardless of who owns the land the lines cross. These don't automatically run with the land unless they're commercial easements.
Your test had a question about prescriptive easements. How does someone get one of those? Sounds like they just take it.
Sort of, but it takes time and specific conditions. A prescriptive easement is created by using another's property openly, notoriously, so the owner could know, continuously for the required period, 5 years in California, and hostilely, meaning without the owner's permission.
Like the example of Thomas using his neighbor's land for 30 years to get to his property.
Exactly. If he did that openly, continuously, and without permission for at least 5 years, he could potentially gain a legal right, an easement, to continue that use, even if the neighbor objects later.
An easement by necessity. That sounds straightforward.
It is. It's granted by law when a property is landlocked, meaning it has no legal access to a public road except by crossing adjacent land. The law essentially provides a right-of-way out of necessity to make the land usable. Your test correctly identified this for landlocked parcels.
Now, the big confusion point, adverse possessions versus prescriptive easement. What's the difference? They sound similar.
They do share those elements of open, notorious, hostile, continuous use. But the outcome is different. A prescriptive easement grants only the right to use a portion of the property for a specific purpose. Adverse possession, if successful, grants full ownership, title to the property.
Full ownership. Wow. Is it easy to get?
Not in California. Besides the 5 years of open, notorious, hostile, continuous possession, to claim adverse possession here, you must have also paid the property taxes on the land you're claiming for all 5 of those years.
The tax payment is the key difference for ownership.
It's the crucial hurdle for adverse possession in California. No tax payment, no ownership claim, though you might still get a prescriptive easement for use. Your test definitely wanted you to know that distinction.
Okay, that clarifies it. Now, lien-ins, these are financial claims, right?
Exactly. A lien is a charge or claim against a property that provides security for a debt or obligation. If the debt isn't paid, the lien holder can force the sale of the property to satisfy the debt.
Are they always created on purpose, like a mortgage?
No. Some are voluntary, like a mortgage lien you agree to when buying a house. Others are involuntary, created by law without the owner's consent. Think property tax liens, mechanics liens for unpaid construction work, or judgment liens resulting from lawsuits.
And general versus specific. Your test mentioned these.
Right. A specific lien attaches only to one particular property, like a mortgage or a property tax lien. A general lien, however, attaches to all property owned by the debtor, both real and personal. Examples include judgment liens or federal income tax liens.
What about lien priority? Who gets paid first if the property is sold?
Priority is crucial. The general rule is first in time, first in right, meaning liens usually get paid in the order they were recorded.
Usually. Is there an exception?
Yes, a big one. Real property tax liens, ad valorem taxes and special assessments automatically take first priority, regardless of when they were recorded. They jump to the front of the line, government gets paid first.
So that creates senior and junior liens.
Exactly. Senior liens have higher priority, like property taxes, than maybe the first mortgage. Junior liens have lower priority, like second mortgages, judgment liens. In a foreclosure, senior liens get paid in full before any money goes to junior lien holders.
Okay, that hierarchy is important. Let's move into the money side. Valuation and financing. How do we determine property value?
The gold standard is an appraisal. An appraisal is a formal, impartial opinion of value developed by a licensed or certified appraiser for a specific property as of a specific date and supported by market data and analysis. Your test stressed that the appraiser's job is to estimate value, providing an unbiased professional opinion.
And appraisers need to be licensed.
Yes, in California, they're licensed and regulated by the Bureau of Real Estate Appraisers. And remember, home inspectors cannot give opinions of value. Appraisers use their analytical skills, knowledge of market trends, and must clearly distinguish facts from opinions.
What about what real estate agents do? The CMA.
Right, the Comparative Market Analysis, CMA. This is an agent's evaluation of what a property is likely to sell for based on comparing it to similar properties that have recently sold, comps, are currently listed, or failed to sell. It's less formal than an appraisal, usually free, and a key tool for advising sellers on listing price and buyers on offer price.
How does a CMA differ from an appraisal then? Your test contrasted them.
Key differences. An appraisal requires a specific license and involves a fee. A CMA is prepared by a real estate licensee, often free, as part of their services. An appraisal follows strict standards, U.S. PAPE. A CMA is less standardized, but both typically rely heavily on the sales comparison approach to estimate market value.
What's a BPO, broker price opinion?
Similar to a CMA, a broker price opinion, BPO, or broker's opinion of value, BOV, is a broker's written estimate of value, often used by lenders in situations like foreclosures or short sales, where a full appraisal might not be needed or is too costly. It's generally quicker and cheaper than an appraisal.
Okay. Now, getting the money, the lending process. What's the first step, usually? Pre-qualification or pre-approval?
Good question. They sound similar but aren't. Your test distinguished them. Pre-qualification is very informal. A lender asks basic questions about income and debt and gives a rough estimate of how much you might borrow. It's based on unverified info.
And pre-approval.
Pre-approval is much more serious. You actually apply, the lender checks your credit, verifies your income and assets. If you qualify, they issue a pre-approval letter stating a specific loan amount you're likely eligible for. It's a much stronger position for a buyer.
After you have a contract, the loan goes to.
Underwriting. This is the lender's deep dive into assessing the risk. The underwriter analyzes the borrower's entire financial picture, income stability, credit history, FICO score, assets, debts, overall net worth, and also evaluates the property itself as collateral. They look at the 5 Cs: capacity, credit, capital, collateral, and conditions.
Credit reports and FICO scores are obviously big here.
Huge. They show your history of managing debt and are a key predictor of future repayment behavior. Higher score usually means lower risk, better terms.
How do lenders decide if you can afford the payments, those ratios?
Yes, qualifying ratios, two main ones: the payment-to-income ratio, or front-end ratio. This compares your proposed monthly housing payment, PITI principal, interest, taxes, insurance, to your gross monthly income. Your test had George with $2K PITI and $8K income. That's a 25% ratio, 2K, $8K. Lenders have guidelines for this.
And the other one.
The debt-to-income ratio, or back-end ratio, this is broader. It includes your PITI plus all other recurring monthly debt payments, car loans, student loans, credit card minimums, compared to your gross monthly income. This gives a fuller picture of your overall debt load. It requires pulling your credit report.
What about the loan-to-value ratio, LTV? Your test had a calculation.
LTV is fundamental. It's the loan amount divided by the property's appraised value or purchase price, whichever is less. So Barry's $90K loan on a $120K property, 90K, $120K equals LIBOR at 0.75 cents, or a 75% LTV.
And why does LTV matter?
Higher LTV means the borrower has less equity, skin in the game, making the loan riskier for the lender. Loans over 80% LTV typically require private mortgage insurance, PMI, for conventional loans.
Is valuation different for commercial properties? Your test mentioned DSCR.
Yes. For income-producing commercial properties, lenders often use the debt service coverage ratio, DSCR. It's calculated as the property's net operating income, NOI, divided by its total debt service, annual principal and interest payments. Lenders want to see a DSCR above 1.0, ideally maybe 1.2 or higher, meaning the property generates enough income to cover its own debt payments with a cushion. It focuses on the property's financial performance.
Okay. And the government steps in with regulations here too, right? TILA, RESPIA.
Absolutely. The Truth in Lending Act, TILA, requires disclosures about credit costs. The Real Estate Settlement Procedures Act, RESPA, prohibits kickbacks and requires disclosures about settlement costs. And the Consumer Financial Protection Bureau, CFPB, created post-financial crisis, implemented major changes for transparency.
Like those specific forms, the LE and CD.
Exactly. The CFPB introduced the loan estimate, LE, and the closing disclosure, CD.
What's the loan estimate?
The LE combines earlier disclosure forms, good faith estimate, initial TLA. It standardizes the presentation of loan terms, estimated closing costs, and key risks. Lenders must provide it within 3 business days of receiving a loan application. It's designed for easy comparison shopping between lenders.
And the closing disclosure.
The CD combines the final settlement statement, HAD1, and final TILA disclosure. It provides the actual final details of the loan terms and all the closing costs for both buyer and seller.
And there's a timing rule for the CD, right?
Yes, a crucial one. The borrower must receive the closing disclosure at least 3 business days before the scheduled closing date. This gives them time to review everything, compare it to the loan estimate, ask questions, and avoid surprises at the closing table. Your test identified this as the form itemizing lender fees and highlighted the CFPB's role in creating it for transparency.
Okay, last financing bits. Discount points and lender credits.
Right. Discount points are prepaid interest. You pay a fee up front, 1% of the loan amount, to get a lower interest rate over the life of the loan. Lender credits are the opposite. The lender gives you a credit towards your closing costs, but you accept a slightly higher interest rate. It's a trade-off between upfront costs and long-term interest paid.
Got it. Now the final hurdle, escrow and closing. What exactly is escrow?
Escrow is a process using a neutral third party, the escrow holder, who holds onto funds, documents, and instructions from the buyer and seller. They only release everything once all the conditions of the purchase agreement have been met. It's a way to ensure everything happens correctly and simultaneously.
What's needed for a valid escrow?
2 main things: a binding contract between the buyer and seller, like the purchase agreement, and the conditional delivery of documents and money to that neutral third party.
Who can be an escrow holder in California?
Typically licensed escrow companies regulated by the DFPI. Also, certain entities are exempt from separate licensing, like banks, attorneys acting in their capacity as attorneys, and title insurance companies.
And brokers. Your test asked about this. Can they handle escrow?
Yes, but only under very limited circumstances without a separate escrow license. The broker must be acting as the listing or selling broker in that specific transaction. They can't primarily be in the escrow business or advertise escrow services separately. Only the broker themselves, not their agents, can act as the holder, and all funds must go into a trust account. It's a narrow exception.
Okay. How does the escrow holder know what to do?
Through the escrow instructions. These are detailed written directions signed by the buyer and seller, outlining exactly what needs to happen for the deal to close, paying off liens, prorating taxes, recording the deed, dispersing funds. They can be separate instructions from each party, unilateral, common in NorCal, or one set signed by both, bilateral, common in SoCal.
What if the buyer and seller give conflicting instructions? Your test mentioned an interpleader action.
Right. If there's a dispute the escrow holder can't resolve based on the instructions, they can file an interpleader action with the court. They basically deposit the disputed funds or documents with the court and ask the court to decide who is entitled to what. This protects the escrow holder from liability for making the wrong decision in a dispute.
Smart move for the escrow holder. The closing costs. Who pays what? It seems like a lot.
It can add up. Buyers typically pay for things related to their loan and inspecting the property. Appraisal fee, loan origination fees, discount points, lender's title insurance policy, recording fees for the deed and mortgage, sometimes survey fees, notary fees, maybe prepaid interest, property taxes and insurance reserves for their impound account. Also, possibly HOA transfer fees or prorated dues, and their share of the escrow fee, often split.
And sellers.
Sellers typically pay the real estate commission, the owner's title insurance policy in many parts of CA, but negotiable, their share of the escrow fee, any HOA dues up to closing, fees to clear existing liens like their mortgage payoff, potentially attorney fees, and usually the documentary transfer tax.
Documentary transfer tax, California specific. How's it calculated? Your test had one.
Yes, it's a state-county tax on the transfer of real property. The rate is dealers and 55s per $500 of the sales price, or the value of consideration, or fraction thereof. For Athena's $735,000 home, $735,500 is 1470 units, 1470 excluding tokens and 5,550 census. Typically paid by the seller, but negotiable.
Okay. And how do you calculate the net to seller? Test question on that too.
Simple concept. Seller's credits, primarily the sales price, minus seller's debits, all their closing costs, loan payoffs, etc. So that $500 K sale price minus $10 gate costs minus $123K mortgage payoff, $367,000 net proceeds to the seller. Credits minus debits equals net.
What about costs that cover periods overlapping the closing date, like taxes or HOA dues?
Those are handled through proration. Accrued items are expenses the seller owes for the time they own the property but haven't paid yet, like property taxes billed later. The buyer gets a credit from the seller for the seller's share. Prepaid items are things the seller paid in advance that cover time after closing, like HOA dues paid for the full month. The seller gets a credit back from the buyer for the buyer's share. Escrow handles these calculations.
And they use that 360-day year sometimes, the banker's year.
Yes, for prorations, using a 360-day year, 30 days per month, simplifies the daily rate calculations. Your test noted this benefit. Finally, reconciliation is just double-checking that all the debits and credits on the closing disclosure add up correctly. Your test also confirmed that title insurance and inspection fees are non-recurring closing costs. You pay them once for the purchase process.
All right, almost there. Legal land descriptions and measurement. Why do we need special descriptions beyond a street address?
A legal description, as your test asked, provides a precise, unambiguous identification of a specific parcel of land that distinguishes it from all others. Street addresses can change or be inaccurate. Legal descriptions are meant to be permanent and legally sufficient for documents like deeds.
What are the main methods?
3 main ones. First, meets and bounds, oldest method. It starts at a definite point of beginning. POB could be a physical monument or a survey marker, and describes the property boundary using distances, meets, and directions, bounds like compass bearings, eventually returning exactly to the POB to close the loop. Your test mentioned Ruby the surveyor using this.
Okay, like drawing the property lines with words.
Exactly. Second, the lot and block method, also called the recorded plat method. Your test used both terms, very common in subdivisions. It refers to a specific lot number, block number, and the name of the recorded subdivision map filed in county records. Much simpler for platted areas.
Like Lot 5, Block 2, Happy Acre subdivision.
Precisely. Third is the government survey system, or rectangular survey system. It uses a grid system based on surveyed north-south lines, principal meridians, and east-west lines, baselines. It divides land into 6-mile by 6-mile squares called townships, and each township into 36 one-mile square sections, 640 acres each. California uses 3 baseline meridian systems: Humboldt, Met Diablo, and San Bernardino.
So descriptions sound like any 14 of Section 12, T3N, R2W, SBM.
Exactly like that. Okay, quickly on measurement. Area is length x width, and the key land measurement. 1 acre equals 43,560 square feet. You need to know that number.
Like Fortina's property on the test. 550 feet by 640 feet, divide by 43,560.
Gives you about 8.08 acres.
Right.
Basic math, but crucial.
Okay, last section. Real estate specializations and property types. Can agents specialize?
Absolutely. It's often a good strategy. You can specialize by client type, like exclusively representing buyers, as your test noted, by property type, residential, commercial, etc., by transaction type, sales, leasing, property management, by geographic area, or even by relationship type, consultant versus commission agent. Gaining niche knowledge helps you serve specific clients better.
What are the main property types by use?
Residential, used for habitation houses, condos, apartments. Your test clearly defined this purpose. Manuela, focusing on townhomes, fits here. Commercial, used for business to generate revenue: offices, retail, restaurants. Again, the test focused on that revenue generation aspect. Industrial, manufacturing, warehousing, distribution centers. Agricultural, farms, ranches, vineyards, cultivation of food, feed, fiber. Special purpose, properties with a unique, often limited purpose: schools, churches, cemeteries, government buildings, sports arenas. Your test noted these can be challenging due to the niche knowledge required and infrequent sales.
What about manufactured homes? Real or personal property?
They start as personal property, but they can become real property if permanently affixed to an approved foundation, utilities connected, wheels removed, and the proper state procedures followed, like getting the title registered with HCD.
Okay. And finally, common interest ownership properties, like condos.
Right. Properties where you own part individually and share other parts. Condominiums. You own the airspace within your unit separately, plus an undivided interest in the common areas: land, hallways, roof, pool, etc.
Planned unit developments, PUDs.
PUDs often mix housing types, maybe single-family homes on individual lots, with shared common areas and amenities, all governed by an HOA. Differs from condos where you don't own the land under your unit.
Cooperatives, co-ops. These are different, right? Your test had this.
Very different structure. In a co-op, you don't own real estate directly. You own shares of stock in the corporation that owns the building. That ownership gives you a proprietary lease, granting the right to occupy a specific unit. Financial health of the corporation is key.
Timeshares.
You buy the right to use a property, typically a resort condo, for a specific period each year. California's Timeshare Act gives buyers a 7-day right to rescind, cancel the contract.
And what law governs these HOAs and community associations in California?
The Davis-Sterling Common Interest Development Act. It provides rules for governance, financial management, disclosures, and owner rights in condos, co-ops, and PUDs. It's the main consumer protection law for these developments.
Wow, okay. We have covered a lot of ground, from agency complexities to ownership types, financing hurdles, closing details, and property niches.
We really have. We've hit those specific concepts from your practice test agency duties, property rights, calculations, disclosures. The goal was to connect the dots and build a stronger understanding.
Absolutely. Hopefully those areas that felt fuzzy before now feel much clearer. Going through this deep dive, really focusing on those points, should build a much stronger foundation for you. Remember, tackling these tricky areas head-on is how you build real confidence.
It truly is. So as you continue preparing, maybe think about this. What single concept, maybe one we discussed today that seemed really complex at first, now feels like the clearest example of why your knowledge, your expertise, is going to be so incredibly valuable to your future clients when you guide them through this process? Keep digging, keep learning. You've got this.